Let me ask you something uncomfortable. If something inside your firm went wrong right now, would you know in the first 10 minutes? Or would you find out when a client calls angry, or worse, when opposing counsel does? Hi, my name is Jesse Castro. Some people call me the firm protector because I help serious firms eliminate silent exposure before it becomes public knowledge. Over the next 4 weeks, I'm going to walk you through something most personal injury firms never intentionally build: leadership, structure, and control. Now, this is not theory, and this is all about standards. This week, we start with leadership, and specifically, threat awareness and red flag instinct. Because the greatest exposure in your firm isn't outside the building, it's unrecognized behavior inside. Your operation is one of the highest trust environments in business. You have medical records, you have settlement documents, you have financial disclosures, private client conversations. Your firm handles information that can influence seven-figure outcomes, and yet most firms rely on assumption. They assume their team knows what to look for, they assume someone will speak up when it feels off, and they assume nothing serious will happen. But serious firms, they don't operate on assumption. They operate on standards. And the first two standards that separate protected firms from exposed firms are threat awareness and red flag instinct. Now, threat awareness is not paranoia. It's professional maturity. It means your team understands what normal looks like, and more importantly, what it doesn't. Let me tell you a little story. I spoke with a firm that had been running successfully for well over a decade. It had a very strong reputation, strong referral base, and it was a high case value. One afternoon, an intake coordinator received what looked like a routine request. It referenced an active case, it included clients' real names, and it appeared urgent. So she forwarded the documents without hesitation. She wasn't careless and she wasn't reckless, but what she was unaware. What followed wasn't catastrophic, but it was costly in time, trust was shaken, internal chaos, and partner frustration. The problem wasn't the employee, the problem was the absence of threat awareness as a standard. High-performing firms, they don't assume awareness. What they do is cultivate it. What they do is reinforce it. And most importantly, they expect it. Because in personal injury firms, awareness protects case value. So here's another example. A paralegal working remotely logs in from a coffee shop between court appearances. Well, that's totally normal, except public networks are not neutral environments. And when behavior is casual, exposure increases quietly. There's no alarms, there's no dramatic events, just slow, invisible risk accumulation. Threat awareness is not about fear. It's about raising the professional standard of everyone inside your firm. So let's go just a little bit deeper. Threat awareness is knowing what's dangerous. Red flag instinct is sensing when something feels off. And trial lawyers, they live off instinct. You can tell when opposing counsel is bluffing. You can sense when a case is getting ready to turn. But most firms don't train the same instinct internally. So here's another story. A firm administrator noticed unusual login behavior, and this was late at night. Nothing dramatic, nothing obvious. It just didn't feel normal. She hesitated. She didn't want to make it a big deal. 2 days later, they discovered that unauthorized activity could have been contained immediately. So here's the truth. The difference between inconvenience and crisis is instinct. Most firms don't have a technology problem, they have a hesitation problem. They have a culture problem. Red flags get ignored because no one wants to overreact. But in personal injury law, delay compounds damage. Red flag instinct means if something feels wrong, it moves immediately. No embarrassment, no delay, no hierarchy of confusion. Just immediate response, and that protects reputation. Reputation in personal injury law is built in decades and damaged in an afternoon. One internal oversight can disrupt case flow, it can create client distrust, it can invite scrutiny, damage referral relationships, and the worst part, most exposure doesn't look dramatic at first. It looks small, it looks harmless, until it isn't. The firms that avoid crisis aren't lucky, they're intentional. They build threat awareness into the culture. They build red flag instinct into behavior. Serious firms don't operate on hope, they operate on standards. Threat awareness is a standard. Red flag instinct is a standard. And standards must be institutionalized. They must be reinforced. They must be visible. Because exposure doesn't announce itself. It reveals itself slowly. Unless you're trained to see it, the goal isn't fear. The goal is control. Because the question isn't whether exposure exists, we know it exists, is whether your firm recognizes it before it becomes public. Threat awareness and red flag instincts are no longer optional in modern personal injury law. They're the difference between control and crisis. If you're a personal injury partner who takes reputation seriously, then follow this series. Next week, we're going to talk about something even more dangerous than ignorance. It's silence, and how reporting culture separates stable firms from vulnerable ones. So start asking yourself, would my firm recognize exposure immediately, or would we discover it after the damage is already done? So subscribe and share this with your partners, and I will see you next week.